for major national newspapers to throw abuse at the judiciary in that way and use a phrase that was redolent of Robespierre, of Hitler and Stalin was just unacceptable in a modern democracy. Her period as Lord Chancellor showed the issues that will subsequently arise when she had more senior posts, particularly that of Prime Minister, of someone who doesn't listen, doesn't take advice, and doesn't understand the Constitution.
You effectively got rid of her from that position.
It's always difficult to say.
This is The Judges, Power, Politics and the People, hosted by the University of Law. This week, I'm speaking with Lord Thomas of Cwmgiedd. John Thomas was Lord Chief Justice from 2013 to 2017. He found himself in the eye of the storm when he and fellow senior judges ruled that the government needed the approval of Parliament for triggering Brexit. Their ruling led to an infamous front-page tabloid headline, "Enemies of the People." He also endured a turbulent time in his 4 years as Lord Chief Justice, clashing with Liz Truss, then Lord Chancellor. John Thomas was born and grew up in Wales. He went to Rugby School and read law at Trinity Hall, Cambridge, and then took a further law degree at the University of Chicago before studying for the bar. He went on to forge a successful career in commercial law. In 1996, he became a High Court judge, and from 1998 to 2001 was presiding judge of the Wales and Chester Circuit. By 2003, he was in the Court of Appeal, and in 2011, president of the Queen's Bench Division. 2 years later, he was appointed to the post of Lord Chief Justice. I began by asking Lord Thomas about his early life growing up in Wales.
The biggest place around it is called Ystrad Gunlais, and Cwmgiedd is one of the little hamlets that makes it up. It was essentially an old mining village. People there were coal miners, because Ystrad Gunlais was a town that grew up as a coal mining and also as a steel-making town.
Did you go to the local school there?
I only went there until I was 7.
And then it was off to rugby?
No, I was sent to a prep school in London.
Right.
And then I went to rugby. My father was a lawyer. He was a solicitor. He also did other things. He was the coroner, the under-sheriff, clerk to the justices, chief registrar. He did a lot of jobs. And my mother, during the war, although she'd been a domestic science teacher, never qualified as a lawyer, but used to work with him during the war and carried on. She actually was a very good lawyer, but wholly unqualified.
Oh, right. So this is how you came to go into law?
Yes.
It wasn't just something you suddenly thought, I'd love to do it.
No, I didn't quite get there as I intended. I had wanted to read economics at university, but I was persuaded it was a good idea to read law. And people won't believe me these days when I tell them that actually they couldn't get people to read law.
Did you have ambitions right in those early days to be a judge?
No, I went to commercial law by a chapter of accidents. I was going to go to a Welsh circuit set of chambers in London, but someone said, well, why don't you come and have a look at this? So I did. And I don't think, and so I came into it by accident. I don't think I ever knew for certain I wanted to become a judge. That didn't raise its head until I got until after I'd been in Silk a few years.
Later on, exactly.
Mm-hmm. Yep.
And springing to that point, why was it that you did decide to go for the bench? Because you must have enjoyed being an advocate.
I think 2 reasons. One, I had seen what happens to people when you reach an age where you can't be an advocate. You reach that at a certain stage. I think these days you'd be slightly more comfortable because the earnings of the bar are so much greater that you can actually retire. And secondly, I think that there was a strong tradition in my chambers that you should give a bit back. And that's...
Yes, because obviously it meant quite a cut in income, didn't it?
Yes.
But presumably you felt you'd made enough, or adequate.
I had adequate.
Commercial bar.
I had adequate, and they also, and I think this influenced people. You know, you did have the security of your judicial pension, even when I became judge in 1996.
So you then quite speedily went up the judicial hierarchy. And I'd like to move now to your top position of Lord Chief Justice. By then, you were already head of the Queen's Bench Division, president of it. Why did you go for the top job?
Partly because I'd worked very closely with my predecessor, Lord Judge, and had a pretty good idea of what it involved. And partly because I felt there were certain things that we needed to get done. I knew when he was retiring that I would have a relatively short period of time, 4 years, but probably in the end, 5 years, 6 years, the absolute maximum you these days can do as Chief Justice. Both those things I wanted to do. And I'd found that working closely with him and in relation to the way the system was working, there was an opportunity to do a number of things.
So you had your plans and your ambitions for the job.
Yes.
You had to apply, didn't you?
Yes.
I think. And what did that involve? Did you have to write an essay? Or?
Well, no. We were going no. Well, you got interviewed. What happened at that stage is the Judicial Appointments Commission was still only about 10 years old. And they hadn't yet got to the stage, which you do in most jobs these days, is provide a CV and provide a short statement. And they were, at this stage, they hadn't got to the shortness of the statement and they hadn't got to the CV position. And so, no, it was a very long, complicated form to fill out. One had to write quite a long piece. It was far too long, but word limited. And you had to set out what you wanted to do.
And what did you want to do?
Well, the three things, I think. First of all, there was absolute need to modernize the administration of the system in two respects. First, in respect of IT, and I had a lot to do with that since I became judge in charge of the commercial court. And secondly, was to make certain that we kept times for delivery of judgments, hearing of cases, to what is acceptable publicly. I think people often forget that actually what the litigant is generally interested in is getting the case decided and heard. There was that needed to be done. I also felt we ought to strengthen the governance of the judiciary. It was about 10 years since, or less than that, 8 years since the Constitutional Reform Act, and we hadn't bedded down a system of governance properly. And thirdly, I was quite keen on trying to strengthen our international work, particularly in relation to our then position in Europe. And those, I think, were the main three things I was interested in. But I also wanted to be sure that I had the time to be a judge, because for two reasons. One, you become a lawyer, and I still like writing judgments, believe it or not. Firstly, and secondly, if you are perceived by your professional colleagues to be an administrator, you lose authority.
Yes, it's a job, isn't it, of huge power. Was it as you anticipated, or did it turn out differently?
Well, I didn't anticipate one or two uncomfortable chapters one had. On the whole, it was pretty much as I anticipated it. Difficulties over money were a constant theme. I was pleased we got a decent settlement for IT, and I think we made a lot of progress on international relations. But it's a tough job.
It is. The challenges, as you say, we'll go to them one by one. But money, you really were a figurehead fighting for the judiciary, for their resources, weren't you?
Well, I think it's a problem every judicial system faces. Fortunately, I once went to talk to the judges in Norway. And there, when the judges suggested closing a court, the local politicians said no, they didn't want to close the court because they had so much money. But if you look at virtually the rest of the world, every judicial system is short of money. And some, like the US system, has a direct subvention from either the federal or state governments. The judges negotiate directly with the government. In others, you get a grant from the parliament. But whatever the system is, you're always fighting for funds. And that has been our problem and remains our problem.
You had to be quite a skilled negotiator and a tough one. The job has changed, hasn't it, hugely? And it had changed in the time, as you say, you mentioned the Constitutional Reform Act. Between then and when you took the job on, the role had radically altered. How would you define the change? Well,
because the Lord Chancellor is no longer the head of the judiciary, and because the Lord Chancellor has taken on a lot of other responsibilities, you have a primary duty to make certain the judicial system runs. And that's why we had quite a long negotiation about the status of Her Majesty's Court Service, the court administration, because in the end, I took the view, and one of the senior presiding, I think both of them, my principal senior presiding judges I work most closely with, Brian Leveson and John Goldring, we were all of the view that it was critical that the judiciary had effective control over the administration, rather than the other way around. We always put it, and once looking back now, today, we did not want to be in the position of NHS doctors.
No.
Having the administration run them, we wanted to make certain the administration did what we wanted.
And was that something that had to be argued? I mean, was it a risk?
Very, very, very toughly we did it. It took about 2 years because the Constitutional Reform Act didn't deal with it. I remember writing a memorandum for Lord Wolfe, who was in charge of the negotiations, with Sir Jack Beatson, putting forward the idea of Lord Brown Wilkinson, who originated this, that the judges should run the administration. And traditionally, if one goes back over the centuries, they'd done so.
But it wasn't clear.
It wasn't clear, and we had to fight for it, and we fought for it in tortuous negotiations that took the best part of 2 years. And we only established it in 2008.
So that was a real threat at that time to the status and power base of the judiciary, really.
Yeah, because if you're to run an efficient court service, you need to be sure that the judge will be able to give the directions to the administration. This is what we want you to do, not interfere in the day-to-day administration, but be sure that the administration is geared to the efficient administration of justice, which ultimately, as the judges are accountable for that, you need to control the apparatus which gives it. And so it was quite a battle.
Quite a battle. And who was the battle with? Who did you do the discussions with, and who did you have to persuade? Would that have been the Lord Chancellor of the day?
The Lord Chancellor was a large part of it, and his civil service.
And who was the Lord Chancellor at that point?
It was Charlie Faulkner for a while. Wasn't very keen on the idea at all, and then with his principal civil servants, quite often, quite a large part of the time, with Annex Allen, who was much more sympathetic and understanding.
And how did you then finally entrench it, if you like, to make sure that was going to be the case?
We entrenched it in what's called a framework agreement. A framework agreement is, as I've since discovered, a very favourite way of the Treasury setting up quasi-independent bodies. And we had a framework agreement which made the court service accountable both to the Lord Chief Justice and to the Lord Chancellor. And so you got a structure that worked. And it had the advantage of the Lord Chancellor being party to it, because obviously he was the person who had to get the money. But you made certain that the judiciary had a considerable say in what then happened. And in particular, what I was concerned to be sure about is that as we have such excellent Crown Court family judges and civil judges, that they had the means of telling the civil servants who were running the admin of the local courts how they wanted it to run so that it would run efficiently.
So these were the negotiations going on before you actually got the job as Lord Chief Justice?
Yes, that I did as senior presiding judge, and then under a sort of special appointment thereafter.
Right.
So this was in 2006 to 7. It was several years before.
Several years before. So the scene was set for the position of your role, or the standing of your role, by the time you came to the top job. And I think, probably the thing that people remember most about your time in that, it might have been 4 years, but it was a very, very turbulent time, and a time of unprecedented tension, wasn't it, between your office and ministers? So perhaps...
Well, I will tell you this. My first Lord Chancellor was Mr. Grayling. And I found him a very easy person to deal with. He was very pleasant. He wanted to make some changes, but by and large, he listened to us. But his ability to get money from the Treasury was not that great. And he was circumscribed in the last couple of years by the question of should we leave the EU, and also huge financial pressures. But he introduced some things that weren't very sensible, such as trying to make defendants pay the costs of their criminal trial if they went down.
Yes, I remember. Yes.
It was not a very sensible thing, because most people who were convicted don't have any money at the end of the day. After Grayling, we were very lucky in having Michael Gove. I found to have been excellent. He was the person who had sufficient political clout.
Even though he wasn't a lawyer, some people regarded that as a requirement for the job. But
no, there's a balance you have to strike. And if I can illustrate this by Michael Gove. See, he being one of the key members of the government, and it has been for a long time, could go and persuade the Chancellor that you needed money. And he was the person who got us the money to modernise the IT.
He had the clout.
He had the clout.
That Grayling didn't have.
He had the clout that Grayling didn't have. Also, he was much more interested in justice, in its social effects. And he did accept the constitutional division of powers. There were one or two occasions where there was a little tension, but on the whole, we managed to resolve them.
After him, you had to deal with Liz Truss.
Yep.
We'll come to her. And winding back the clock a little, you had the very, very key ruling. You led the court, a panel of 3 senior judges, in the Gina Miller challenge to the government over whether Parliament had to approve the triggering of Brexit. That led to the probably most famous clash between government and judiciary in recent times. I'd like to ask you first, when you sat on that case and you were about to rule in favour of Gina Miller, who was challenging the government, did you appreciate the impact of your decision?
Yeah, I think we did. The one clear thing we did was that we were not prepared, as is usual, to allow a draft of the judgment to be circulated 24 hours ahead of time.
Because of the controversial nature
We said that counsel could come and read it in the Royal Courts of Justice at a particular time, so there was no risk
of it leaking.
Okay. So, and secondly, because at the time there was the view expressed in the press, and I assume it was right, that although the government was determined to serve the notice under Article 50 of the treaty to take us out of Europe, there were many in Parliament who didn't want to do that. They didn't regard the referendum as necessarily binding, but there were a very strong press and other lobby that, having achieved the victory, they didn't want it snatched from them. So the political tension was great. And by the case that Jeannie Miller brought, which was to say you have to put this through Parliament, I think a lot of people thought, oh dear, this may slip from our grasp, and therefore the tension was very high. By the time the case got to the Supreme Court, the position of Parliament had changed, and so the tension wasn't so great.
Less. But of course, your ruling led to the infamous headline, Enemies of the People, and a huge outpouring of vitriol against you and your colleagues. Were you prepared for that, and what did it feel like?
I wasn't prepared for the vitriol, but when it came, I think what concerned me, particularly as there had been a murder of an MP by someone who was not quite balanced, I was concerned for the safety of my fellow judges, because one knows that when emotions are stirred, you can get people who aren't entirely balanced. This is the first time that I asked that we have proper security surveillance and checks on our respective houses. And I had done Al-Qaeda cases, for example, the airline bombers case, where they were going to blow up all these. I did all the appeals in those and upheld these very, very long sentences. But when one checked with the security services, was there a problem? They said no. But on this, it's the first time. So there was a personal problem.
It must have been hugely worrying and a little frightening, perhaps.
Well, because you're always worried about what someone who's not entirely balanced might do. Yeah. And secondly, the kind of one anticipated that the government would not be happy because it meant they would have to go to Parliament and the risks of that involved. But I didn't anticipate, though looking back in it, I probably should have done, the way in which the press ran, particularly the Daily Mail,
What did you think about that reaction?
It came as a shock that they were so vitriolic.
And of course, it wasn't just the reaction in the press and in Parliament. You had judges, circuit judges, who would raise, I think you said at one point, they would raise it.
Yes.
Or was it litigants, perhaps?
They were concerned.
Litigants would raise it.
They were concerned about the attack on the judiciary in emotive terms. And you are bound in the course of your day-to-day life to upset people by making a decision against them. And so when you turn the pressure on judges in the way that the tabloid press did, and it was also the Telegraph as well.
Yes.
It was a disappointment. And I think what I found particularly disappointing is that Lord Bingham back in 2000 and then Lord Judge following him and I had tried to improve our relations with the press. I had to lunch with another judge always present, people, an editor or senior correspondents, just to talk over the problems. And to find that, the Telegraph and the Mail really behaved in this way without realizing, I think, quite what they were doing was very disappointing.
Do you remember the moment when you saw that front page and what you felt about it?
I thought the attack on Sir Terence Etherton, as he then was particularly unpleasant.
He was master of the rolls at that time.
Yeah, he was the master of the rolls, and the caricature of him, that was just so wrong.
And of course, then matters were exacerbated, I think you might say, because you would turn or expect the Lord Chancellor to stand up and defend you, this being Liz Truss at that time. You weren't able to speak out as the convention has it, to defend judges, but you would expect the Lord Chancellor to do so. Is that right?
Yes, and nor was Lord Neuberger, as President of the Supreme Court, able to do so either, because it was obvious that the government would appeal and go to them, and so he couldn't say anything either, because immediately there would have been the accusation, he's interfering, he's made up his mind, whatever. And so, apart from retired judges and others, one had expected or would have expected the Lord Chancellor to have done so. I don't think it was the fact she wasn't a lawyer that was the problem. I think it was that it suited the political circumstances of the time not to say anything.
She wanted to keep in with the popular press or the right-wing press.
That's what I surmise.
More than sticking her neck out and defending the judiciary, really. She eventually did come and say something. It was rather little too late, wasn't it?
Yep, and it wasn't. It contrasted the judiciary and referred to the need for a free press. It didn't deal with the problem, which was the fundamental one, that for major national newspapers to throw abuse at the judiciary in that way and uses a phrase that was redolent of Robespierre, of Hitler and Stalin, was just unacceptable in a modern democracy.
Well, you made your views very clear later on when you came before the Lord's Constitution Committee, and you spoke about it in terms. The criticism was as strong as I think has ever been made by a serving Lord Chief Justice of the Lord Chancellor of the day. And was that something you planned to do and you thought was right to do?
What I planned to do was, one could say nothing until the litigation was finished, so we had to wait. And I decided that I was going to say something. I felt if you didn't, then the judiciary would feel let down, and that one hadn't made clear that the conduct of a minister in this respect for a balance of powers between the three branches of government was something that would be damaging. And I thought, well, I will do it. I've got to give a lecture. I'd been invited to give the Ryle lecture, which is a lecture that you give in Parliament about legal matters. And my plan was that probably I would deal with it there. I felt if I went to Westminster and gave it as a lecture. But fortunately, the Constitution Committee asked me about it. And that was much more appropriate because I could do it openly. But I was going to be very critical of her because it seemed to me that you cannot let something like that at the appropriate time, distance away where you can't be looking over the judgment that is still current, was absolutely essential for the maintenance of the independence of the judiciary for the future.
And I think you were probably also feeling fired up because only a week or so before, she or her department had put out a story, do you remember, about the pilot scheme on recorded evidence for rape victims, other victims of sexual assault. And they had announced, without any reference, I think, to yourself or the judiciary, this was going to be extended nationwide. Quite wrongly, I think. And you were pretty annoyed about having to deal with the fallout from that.
Well, I think the problem was, and I think I regret to say this is a characteristic of some, that they don't listen as ministers. And it was dealing with pre-recorded evidence is much more complicated than any, you think it's terribly easy, but it's not. There's always the problem with the courts of having the right technology. And when at that time they hadn't got the technology right, you also have to organize it so barristers can be prepared to cross-examine, and you have to see what the pitfalls are. And there were obvious political advantages in saying all this is to be rolled out, and it was obviously wholly impracticable. And I think that occasionally, it's very rare actually, that a government minister will try and put in place reforms for which the system isn't ready, because they generally speaking, listen to you because you know how practically things work. And I just think it was very, very unfortunate that for populist reasons, and it was something that needed to be done, but it wasn't the judiciary's fault it hadn't been done. This had been recommended 20 years beforehand. But it
couldn't just suddenly be then rolled out like that.
You couldn't.
That was the point. Well, your criticism had an effect because she was moved from office not long after. I think, would you accept that you effectively got rid of her from that position?
It's always difficult to say, but I think that her period as Lord Chancellor showed the issues that were subsequently arise when she had more senior posts, particularly that of Prime Minister, of someone who doesn't listen, doesn't take advice, and doesn't understand the Constitution.
But she was only in post 11 months. But I think it's a fair verdict to say that you basically got rid of her from that position. I mean, she went on to do other things, but would that be a fair summary?
I was glad to see that the then Prime Minister had obviously appreciated that relations between the judiciary and the executive would not have been as cordial as they should be if she had continued in office, and therefore she had to be moved. Whether the move was to the right place, that's not for me to say. But I do think what is regrettable is that that people didn't look back at a track record when considering future preferment. And when you're appointing someone, normally you look and see what they've done, how competently they've done it, whether they've listened, etc. And I think it's a regret of our political system sometimes that we don't look at people's track records.
How damaging do you think then, looking back on that whole episode, it was? I mean, yes, she was moved, so that showed that you had the power to effectively express your views and your concerns, and that was acted upon. I mean, looking back on it, has it had lasting damage? And in the eyes of the public as well, I'm thinking.
I hope not. That's why it was important to speak out and say it was wrong. I think if everyone had just let the thing lie, which some may have done, that would have been much more damaging. I think that it is important for the judiciary on something that is a purely legal question. This was a purely legal question, which the courts have had to decide over the centuries as to what the Crown can do under the use of the royal prerogative as opposed to getting to Parliament. And as long as you're dealing with a purely legal issue, it is very, very important to see that your decision is accepted. And I think in the end, although it was a very uncomfortable time and I wish it had never happened, I don't think it has damaged the judiciary in the longer term. People have seen us as completely independent.
What do you think then about the public perception of the judiciary? Has it changed, let's say, over your time and since? Do you think the judiciary has a good standing in the eyes of the public, or how would you?
It's always difficult for me to say that. I think that on the whole, most of the decisions that the judiciary have made, they fortunately steered clear of making what I would regard as decisions in political areas or social areas. For example, abortion never came to be decided. Unfortunately, the Supreme Court decided the right to life case in a way where they weren't going to decide that. I think if judges start making that sort of decision, then their standing has fallen. I think the judiciary has been much more cautious at what it has done. And so in that respect, I think the standing of the judiciary is high. What worries me about the standing of the judiciary, I think, are two things. One is the horrendous cost of access to justice and the diminution of remedies to ordinary people. And in a way, that should reflect on us. Secondly, I think that it is at times difficult to attract people to accept high judicial office. At the moment, we're very lucky. We've got an excellent series of commercial lawyers who are prepared to become and lawyers from what I would call the more remunerative parts of practice. But as long as we keep good judges coming and we address what I think are the fundamental failings, which are a lack of access to justice, the standing should remain high.
Looking ahead, we're now post-Brexit pretty well. Is this going to have an impact on the way judges operate and the way the law is applied?
I think what I hope will be the position is that we will continue our close ties with Europe. I think some believe that the common law was some ingenious creation on this island with no external influence. that is historically nonsensical. And for the future, we have to have good relations between the judges, between the academics, and between the lawmakers, because we all face common problems. They have good ideas, we have good ideas, and the idea we isolate ourselves, cut ourselves off from this development is, to my mind, absolutely foolish.
And would it be dangerous, presumably, to correct development of law in this country?
And we are a trading nation, and we make a lot of money out of international financial services. We have to keep abreast with international practice. And I do. The judiciary is playing a very strong role in this. I don't think this government really understands the importance of this to the future of legal development and London's position.
And if they don't, if they do have an isolationist approach, what then?
I think there are two risks. First of all, our law will not develop as it should, and we will become a less attractive place for people to litigate. And so we have to remember we are not the great trading nation that we were when the huge amount of development took place in the 19th and early part of the 20th centuries. And we have, therefore, to appreciate that an awful lot of international developments occur between the European Union and the United States as major influences, and now, surprisingly, the Chinese, the Singaporeans, the Indians. We have to be there with them, and to make certain that our law and their law develops correctly, and we can be very dominant in the way in which it can develop. Therefore, we should not cut ourselves off. Secondly, I do think there's a real risk in the end to London if we're not seen to be a place which harmoniously respects other laws.
London as a financial centre.
As a financial and a dispute resolution centre. We should be internationalist in our legal outlook.
Sentencing, obviously, is where the public most often see judges and have an opinion of them. And of course, now they see it a bit more because we have more cameras in courts than we did. Do you think that's improved the image of the judiciary? I mean, how is the image of the judiciary in the eyes of the public?
First of all, talking about press reports, I think I'm a great believer in the judges getting communications right. And one of the problems has been that there's been a diminution in the reporting of cases. And if you don't have good reporters, or the newspapers can't afford them, the judges have got to be able to communicate what they're doing. I think it's very undesirable at the end of a case that someone from the CPS or from the police gets up and explains what's happened. It's much better that, because of the move in the times, that the judge in an important case explains what he's done in a short sentencing remark. There's no use. You have to give the whole lot, but you need to build something into the middle which explains in 2 or 3 sentences why you're doing something. And I think it's much better for the standing of the judiciary that they do that. So, and I think what has happened over time is quite easy for politicians to castigate judges for being soft. Lord Woolf was, referred to as the burglar's friend, and it was horrible. More horrible was what happened in about 2005, 2006, 2007, where judges were lambasted quite wrongly for the sentences they gave. And although many judges would say, well, that's part of the price, what I found was that their families couldn't take it, particularly their spouses. They found it. And sometimes they would say, well, look, if you get these terrible attacks on you in the press, your friends begin to wonder. And so I think the communication of why you're doing something is critical. Secondly, I think that government ministers have to be very careful in the way they criticize sentencing, because it's not an easy job. And thirdly, that I would hope that the way in which we now have sentencing guidelines, because I think the system has worked, that it's much easier for the judge to be sure that he is sentencing within the correct band and he's got an objective criteria on which he can rely.
You're much more constrained than people realise. I mean, do you, and I agree with you about the communicating and the summaries and so on, that's all immensely helpful, I think, to the media. But two questions, really. I mean, would you like to see cameras used more in courts than they are currently? And secondly, your own personal experience of sentencing, were there any cases that kept you awake at night?
Let me answer the first question. Yes, I think that we should use cameras more, but we mustn't allow witnesses to be on telly. I mean, there was the case involving, I think it was Nigella Lawson, but someone, where the kind of points that were being run in cross-examination would have made the giving of evidence in that case simply horrible. It was bad enough the way in which it was reported. So there always are cases where you go for the personality or for the subject matter, and that makes giving evidence much more of an ordeal than it is. And I'm not I've only had to give evidence in relation to sort of expert matters or when I've given evidence in Parliament. But it is quite an ordeal giving evidence, and I don't think people realise it. But on your second question, are there difficult cases? Yes. I mean, I give you two illustrations. First of all, I think one of the really difficult cases we did was Sergeant Blackman or Marine A, when we decided initially on the first appeal to reduce the sentence. That was tricky because it was so high profile and there was no real precedent.
Just remind us about the
this was the person who had been a soldier in Afghanistan, and he'd been recorded by one of the platoon of which he was the commander as the sergeant, executing someone on the battlefield. The person was alive, and the sentence we reduced first time round when there was no appeal against the conviction for murder. Second time round, where someone had raised the problem of PTSD, and we heard evidence about that. What did we do with the sentence the second time round? And that actually was very difficult because you were sentencing the same person but in different circumstances. So that was very difficult. I think the second...
And just remind us what you did do.
We reduced them on each occasion. We reduced it further. We had to on the second one.
But it was a hard and worrying, that case.
It was a hard and worrying case. The second one is very different. One of the dreadful things that I think the politicians did was to impose or to hand out a sentence of imprisonment for public protection, IPPs. And it's interesting, very interesting now, that Lord Plunkett, who was Home Secretary at the time, appreciates and accepts it was a mistake. And when when Ken Clarke was Lord Chancellor, the sentence was abolished prospectively, but it was not. We never worked out what to do retrospectively. And when I was chief, we had a whole lot of appeals, which we consolidated into, I think, 12 or 13 cases, where we had to decide, should we, as judges, rewrite the sentence? Or should we, as is very clear, adhere to the rule of law and saying, well, we've got no power to rewrite it. We have to sentence in accordance with the law. And the decision we made was that although if we had a free hand, it would have been wonderful to have been able to look again at these sentences and sentence people according to what the current law is. It was not permissible to do so. Bearing in mind the government's done nothing about the problem,
we still have prisoners languishing.
Yes, the numbers are still significant. And I sometimes regret But actually, when I think about it, it isn't something I should regret because one did the right thing, which is decided according to the law. But the injustice is one of the areas of law where I feel that the system in criminal justice has been most unjust. And I think the other thing I would say about sentencing is that we must reserve long prison sentences for very serious offences. The scale is constantly rising. And there are people who really do need to be sent to prison for a very long time. Terrorists, for one example.
But not for the lower down, the sentences lower down, going up too much.
We're putting them up too much, and we're distrusting too much the discretion of the judges.
Do you think that judges should take into account when sentencing the state of the prison estate and whether there is room, basically? Should they take that into account?
Various people have said so, that should be taken into account. But I think it's very difficult for a judge to moderate a sentence because of the conditions in prison, unless you go to prisons regularly. One of the criticism I would have of judges, they don't go to prison often enough. Lord Wolfe was a great believer in going to prisons. I try to do the same. Because you really do need to see that even in the most modern prison, you can have terrible problems. But in old prisons, they can do something for you. I think it's too difficult for judges to be influenced by the conditions in prison. Obviously, if someone is going to be held in solitary confinement by reason of the kind of offences committed, that is something you can take into account. Or if they're severely disabled, and genuinely severely disabled, because some people feign it, as you sometimes see. I remember on one appeal, it was quite obvious that someone was feigning his disability, and subsequent CCTV showed that. But where someone is genuinely disabled, then I think those are objective factors you should take into account, but not the prison conditions themselves.
Looking at generally the state of the justice system, you mentioned the difficulties of access to justice. What about the state of the criminal law?
The criminal law is something that we need constantly to keep under review. At the moment, that is significantly being done by the judiciary, particularly in the area relating to violence. And I think the changes that have been made in relation to certain mistakes that were made, as judges sometimes do make mistakes, the judiciary has done a good job in correcting them. And I think in particular, in relation to dishonesty, we turned that into effectively an objective test, mitigated by subjectivity. And I think we've now put the balance right. I think the Supreme Court did a good job on that. I also think that we did the reforms that have been made along the way have been beneficial, but it shouldn't entirely be for the judges to have to do that.
Again, this is who holds the balance of power there. The judges make their decisions in rulings, but Parliament will make the law.
Yes.
The criminal law, and rightly so, I would imagine you think.
I would hope. I mean, I've always been a great believer in the codification of the criminal law. It's one of the ironies of history that the judges in the 19th century were wholly opposed to it. And that opposition was at a time where the government of the days were very keen on it. And when Lord Bingham was Chief Justice, he was very keen on the codification of the criminal law, and the politicians were dead against it. And that's been very unfortunate.
Do you regard yourself as a liberal sentencer, a liberal judge, or more on the hard?
I think that's for others to judge. I've handed down some very, very long sentences and upheld very long sentences. We did, for example, uphold the validity of whole life tariffs. And in the cases that I can recall, the worst of all, which was someone who had, through, I have no doubt, the influence of obscene pornography and sadistic pornography on him, had watched a girl he'd trapped into coming into his house, literally slowly be hanged by him to death. Then he violated her corpse and hid it. I mean, it was simply horrific. And for that sort of exceptional case,
life should mean life, is what you're saying.
But they're very few. But I think we've got to be very careful we don't put these tariffs at positions that are unacceptable. I think the problem with the IPP sentence is that it was given for crimes that weren't in themselves that serious, but subject people to a regime of no hope. And if you take away someone's hope, then you make it very, very difficult for that person to redeem himself.
Generally, just looking at the judges now against the background of politics, in recent years, with more populist politics, judges sometimes can be cast as the liberal branch of the constitution as against the executive. Do you think that there's been a shift in the attitude of ministers to the rule of law? We have seen it. We have seen some strange
I think it comes. I think it's fair to that it comes and goes. I mean, I always think it's very important before anyone looks at what's said in the current government that you go back a bit and look what was said before, because you can find some fairly vitriolic things that were said. I mean, one of the members of the Court of Appeal was severely criticised by I think he was the first instance judge then, for certain administrative law decisions he made. So I think that where you make a decision the government doesn't like, the temptation is to attack. I think the judiciary has to be very careful of two things. One, that what you're doing is properly communicated. And two, difficult cases you share around so you don't get one judge who can become the objective, whether it's of a particular faction or whether it's of the government. But I'm afraid, I mean, although we tell the government from time to time, we say, well, we don't accept the decision of Mr. So-and-so as correct, we shall appeal. Nice sentiment. I'm afraid you can't constrain people. It's unrealistic where something's tense to expect people not to be slightly more colourful in their use of what they say about a judge. But the judges, I then think, have to be very careful, as I said a little earlier, that we don't slip into deciding things that should not be the subject of judicial decision.
Yes, and that will then lay you open to having rulings perhaps disregarded. That hasn't happened, obviously, but we have had the present government talking about disregarding European Court of Human Rights rulings. What do you think about that?
Well, I think there are two ways. There are some very learned articles from lawyers who I greatly respect, they don't agree with, who will say we're not bound by the interim rulings under Rule 39 of the court.
We're talking here about the blocking of the flight taking off to Rwanda with illegal immigrants.
And they say this is a jurisdiction invented by the courts. We didn't sign up to it under the treaty, which gave the court its jurisdiction. Therefore, the government's not bound. Therefore, they're not breaking the rule of law if they ignore these flights, if they ignore these rulings. But I take the slightly broader view that if you have subjected yourself to a court, and it was our voluntary decision to do so, and a right decision of Lord Irwin's, then you have to take the rough with the smooth. And if they've decided they have this jurisdiction, then you ought to follow it. You can't expect people to expect others to respect the law if you say you won't respect the law of someone else because they haven't got the authority to do it. If you think they haven't got the authority, then you solve that in the way in which you should do it, through the Council of Europe, politically. but you shouldn't question the authority of the court.
Yes, you can always withdraw, although, that would be a big thing in itself, but they could withdraw from the European Convention.
Or, I'll give you an illustration. In the question, one of the rulings that I think one recalled the Prime Minister Cameron saying there was a ruling that made him sick.
It was about giving prisoners the votes.
Yeah.
Prisoners' voting rights, that made him sick.
Yeah. And, it was, well, I'm not going to comment. But now that was an issue that the government then went on to address in a political manner through the Council of Europe, through discussions. And it hasn't really caused a problem. And it's the realization that the balancing the the responsibility of the judiciary, the responsibility of Parliament, and the responsibility of the executive, they ought to have relations that are good and interdependent. And where something goes wrong, you shouldn't launch into an attack. You should see, well, now, how do we resolve it? And that's what I think sometimes the judges fail to do that, sometimes the politicians fail to do it.
So do you have any particular worries that in recent years there's been more of a cavalier or attitude to the rule of law by politicians?
I think if you ask me where the crunch point is going to come, it's going to be in relation to climate change. Because the way in which the legal system in which climate is regulated and the toughening of the laws all that time, we will reach a position where the political wish not to constrain the consumption of energy or not to look after the environment properly will run into a collision with what the law is. And that's, I think, likely to be a much more contentious issue than the current problems that relate to immigration. The problem with immigration is that we've never properly got the system to deal with it speedily. We haven't put the money into it. The only way properly to solve the immigration issue is so that if someone arrives on, this is not literally Solomon Grundy born on Monday, but if someone arrives on Sunday, you ought to actually be able within a set period of time, say a fortnight, to hear, investigate, decide, give him one right of appeal. Yes. Why you should have more than one right of appeal, I simply don't understand. And remove them.
So streamline the whole thing and speed it up.
But it costs.
It's money.
It's money, and you need to simplify and tighten the procedure. But that's where we ought to be directing our attention. The laws are such that the government will, I am sure, have a clash, because politically they won't want to make the public pay the price of climate change.
That'd be interesting. So watch that space. But looking back now, standing back, do you think the balance of power between the judiciary and the executive is about right? Do you think it's shifted over the years? And if so, in which direction?
I think part of the problem with the balance of power between the executive and the judiciary is the balance of power between Parliament and the executive. If Parliament had more power and was able more effectively to exercise it, there'd be less of a problem. Another area where I think the courts will have to tread very carefully, we have moved in the period, and it's fortunate being in Parliament when I've been able to see it firsthand, we've moved much more to legislation which gives enormous power to the government to make rules and regulations by secondary legislation rather than primary legislation. Therefore, the government reserves to itself a huge amount of powers which aren't subject to scrutiny, to proper scrutiny, to proper argument. And if the parliamentary process is deficient, as I have no doubt it is at present, then you are going to find that the courts will be under pressure to redress the balance. And the extent to which they're prepared to say, no, this is something where, because there is no parliamentary scrutiny, parliamentary supervision of what has happened, this is a matter we can look at. This is going to be very difficult. I'll give you an illustration. In the recent changes to the Public Order Act, which are giving the police more powers over demonstrations, if the particular change had gone through the parliamentary process, you'd have heard the argument both ways. But the government only went to consult those they thought were relevant, namely the police. They didn't consult the protesters. And I think that if you don't have a proper system of secondary legislation where you properly consult, where you enable it to be scrutinized by Parliament and maybe adjusted, then you have a real problem on your hands. And that, I think, if I was to identify a second problem, is the problem of unrestricted secondary legislation will put more onus on the judges. You'll get more judicial reviews. The judges will find themselves in a more uncomfortable position.
Is it looking bleak for the judges in the future?
No. No, I don't think so. I think that
no one will want to be a judge, will they?
No.
They're under scrutiny and they're maybe made to make political decisions.
No.
All that.
I wouldn't.
And the media attacks them.
I wouldn't say that. I think on the whole, the relations with the press, you get aberrations are good. The judges have got to make certain it's good. It's as much up to them as others. Secondly, judges must be very, very clear in judgments that what they're doing is deciding legal and not political questions. And they've got to try, it's very difficult, but you've got to do that. And as to criticism, it would be terrible if judges were not subject to a legitimate and proper criticism. I think someone who writes an article in one of the learned periodicals, saying that you made a decision which was completely contrary to authority, is probably actually much more a stigma to a judge because he's being told by another lawyer he's got his profession wrong than someone's uninformed comment. So I think criticism is very important, and I think it's good that judges are made aware where they're getting too close to politics, and I think it's good where judges are criticised for the legal decisions they make. And if you want to take on an interesting job, you've got to accept that people will criticise your decisions. Otherwise, all your decisions are useless. I always remember being told when sentencing, if you don't get appealed as a sentencing, this was before the days of unduly lenient sentencing being common. If you don't get appeals from you, you're not sentencing properly.
This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.